one call, and I just don't. It's always from El Centro. When I see it, I recognize it. I block the number. Still comes through. Somehow it goes through my block. I don't know how it does that.
I change numbers again.
And maybe there is it looks the same to me.
Mm-hmm.
And they always leave a message, and it's always like, hey, we'd like to talk to you about refinancing your something.
Yeah.
And I'm like, okay, no. And you can't text stop or anything because it's a call. And so I just tried blocking the number, and it gets me nowhere.
Yeah.
So guys, if you want to get started, I was already sharing picture with these gentlemen. Should be a short night tonight. Dean Dolan will not be with us tonight. So before we get too in depth into our lecture, why don't we start with making a decision on what we want to do next week. We are not going to have our mock trial case until next week. So we need to go forward doing cross-examinations, direct examinations, and playing witnesses next week. So here's the way it's going to work, and you guys are going to tell me which case you want to do and whatnot, but it's going to go something like this. Okay, you're going to direct a witness. It doesn't have to be this combination, but you're going to direct. Vincent's going to cross. Will's going to be your witness, right? He's going to direct. He's going to cross. You're going to be the witness. Direct, cross, witness. Everybody's going to be a witness. Everybody's going to do a direct. Everybody's going to do a cross. Okay? So that being said, to the extent you guys want to pick something from the cases that you're already working on, great. It's easy for Vincent because he did too, so now he's somewhat at an advantage now because we're going to have to pick two cases to accommodate you guys, but then you're going to not be familiar with the other case, or he will be. So if we stick with our jackhammer case, right? Well, but it's one you're familiar with.
Yeah.
You know, who you want to direct.
What do you mean?
What witness do you want to question to bring out all the evidence on?
I mean, the main, I guess, would be the rock industries. That's
well, you can call your own witness, your own client as a witness.
You can call your client.
But are we going to go off the questions in here? We have to.
No, you're going to.
You create your own questions.
Yeah.
Yeah, so the big argument with my side of the case is Rock Industries has this thing where they tell all their workers to,
yeah, but is that going to give you an opportunity to conduct a good direct examination, right? I want you to call somebody, ask them 4 or 5 questions. Yeah, that's all I need from this guy. I'm done.
I'm done.
Right, so we want to witness more of a major player such that you can.
I have to do the firemen because then I could have to play on the emotions.
Okay. So, and we'll get into, what's expected of the direct and what's expected of the cross.
Okay.
So you're going to do the fireman. You're going to cross the fireman. You're going to be the fireman.
Show me your toes.
Hang on.
Right.
Here they are in a jar.
Notice, Sean, the first 3 went to market.
Okay. And who do you want to direct? You already got your cross. Who do you want to direct?
I guess it'd be my client.
Your client?
Yeah.
Okay.
There's really no, I mean, the only other person is the Rock Industries person, and they're kind of useless to the case. So. Well, for both sides, I mean, you already settled with them, so, and I can't bring that in, so there's no point in me.
No, but you could do your case with him too, right? So you could pick. You want to do your.
Oh well, yeah. I thought I was gonna have to do two.
No.
No.
It's 1, 1, 1, and 1.
Oh, okay. Then I guess I'll. Well, is the defendant in the criminal case testifying?
Yes.
I thought,
But
yeah.
that's probably, I don't know. Yeah,
Yeah, I think.
I'm gonna have to pick, because you're picking who you're direct. So I'm
Yeah.
gonna pick who I'm gonna direct, which is gonna change. Now I know the one case for this, so I'm gonna pick,
The victim.
you know what? I'm gonna pick, his wife. So you can pick whoever you want.
Okay. Then I'll do the criminal defendant.
But even though you can't really put up criminal defendant in direct?
I'm.
Yeah, you're gonna want to direct somebody from your case in chief.
Okay. So then I guess shit. Then I guess I'll do the victim.
You guys, and what I want you to keep in mind is, right, this isn't a case that we're trying to win or lose or argue. So it's not, oh, the other side can score some points. What we're going to be looking for is how you direct.
The victim. It's not like it's my case. I'm going to win or lose. I don't care if she's shit or not. So yeah, I'll do the victim.
Okay. And you're going to cross the victim.
Cross the victim.
You're going to be the victim.
You're crazy, Victor. I want to see
Your crazy ex-girlfriend.
I want to see
I'm the crazy
the
ex-girlfriend?
Okay.
Alright. I'm the crazy ex-girlfriend.
Who are you going to direct?
I think I want to do the wife instead of the defendant. Yeah, let's do the wife.
Okay. Victor, you're going to cross the wife in their case. I know you're not familiar with it, but you're going to have to, just like he wasn't familiar with the fireman, he's going to get familiar with it. And you're going to be the wife.
Yay!
I'm messing it all up.
I love my husband! God.
Right? That'll,
Yeah, exactly.
you'll have some fun with it. Now, here's what I also want to stress with you guys.
But she doesn't have a story. Why doesn't have a story other than her own
He
little?
was there.
That he was at. There's nothing to talk about with the wife other than to corroborate his
Well, that's
story.
what I'm talking about. I mean, look, you're picking who you want to direct with an understanding that we're looking to see how you direct. And if you're asking 4 or 5 questions, then
Right. I'll choose the defendant.
Don't pick the easy one, you can get you what you want. Was he there? Yeah. Okay.
Yeah, that's all that I can. Where was he? Was he there the whole time? You mean like from the whole time?
Oh, okay.
So where do we get our answers? So can we only obviously ask answers that are based on the case?
based on the facts.
But like, I know like in the book it talks about building their background and up and stuff like that. We really can't do that, can we? Because
Well,
we're kind of in a closed universe.
right, you can only do that to the extent that it's there.
Mhm.
And if you want to ad lib to a point, you shouldn't be ad libbing.
Material facts or something like that.
You know, something that's going to hurt one side or the other.
Okay.
You know, but if you want to ask, you know, so you like beer, and he says, oh yeah, I love, Bud Light, that's my beer. Okay, that's not in the facts, but it doesn't hurt anybody to,
Yeah.
If you don't have a beer in the middle of the day, he probably likes beer. I mean,
so I mean, there's stuff,
5.
it's stuff like that you want to be just cognizant of. And right, you don't want to be as a witness, right, because you don't have a side. You're just doing a side. So you don't want to be shading your witness to one side that you think is yours and going to help your case. helping your case. Just play the witnesses straight, do your solid directs, and what we're really looking for is in direct, are you able to pull out from your witness everything that you need? And to the extent you can't do that, how are you going to get around it, right? You ask them a question. I don't recall. Well, if I showed you this, might that refresh your recollection, right? You show them stuff and you know, to the extent you use the tools that a lawyer would to pull out what you need, okay? And we're going to go through some of those tonight in the lecture, but we expect you to do, you know, what you need to do as if it was a case, as if it was your real case, right? You want to pull out the good information that you need. You want to address the bad information that you think you need to address on direct, you know, cross-examination, right? You're leading, you're telling your story, you're putting words in their mouth. You don't want to let them, you know, take charge and guide the questioning. So, and we'll talk about tactics to do with that. And to the extent you've got an objection, it's okay to object with each other, okay? But your objection should be appropriate, founded on all that stuff you remember from your evidence class, right? And we'll go from there. So y'all know your assignment.
Yeah. What's the this case called?
State versus Grifford. I think it starts on 191.
190, yeah, 191. What's your guys' case name again?
Kent versus Bonds.
Can't be balls.
I think it's like the second case.
Okay. 3-1.
All right, guys. So let's talk a little bit about direct examination. Keeping in mind that what we're really talking about for purposes of our lecture is not necessarily how you would necessarily do it for the class, but to the extent that you can do these things, try to do them, right? You guys are with each other, right, all the time here. If you want to meet with your witness and prepare your witness to the extent, yeah, I really want to get into this area with you, do it.
That's prepare you. That's my witness.
Sorry, I'm gonna be drunk the entire time, so.
Okay, so when you're preparing for your direct, the number one thing is you've got to be familiar with not only the facts of your case, but the evidence of your case as well, okay? And you've got to be able to understand what it is you need to get out of this witness. What is it factually, and what is it from an evidentiary standpoint? You need this guy to lay a foundation for a photograph. You need him to verify that that's a signature on a document. You know, so to the extent that there's exhibits in your casebook, and there are, use them. That is part of the direct process. So you have to understand exactly what it is that you want from them. And then you, in formulating how you want to go about questioning them, you know, you got to make sure that in your mind you have a goal of what it is you need to accomplish. Okay? I'm not a fan of writing out questions. I think it keeps people It prevents people from listening because they're following and they're like, you know, did you do this? No, I did this. Oh, and after you did that, wait a second. Right? They're not listening because they already are. They're anticipating the answers and they're going through. Okay? Tell your witnesses, here's what I'm going to go over with you. Here's what I'm not going to go over with you. Right? If you've got bad facts, you know, sometimes it is to your benefit to bring those out. Sometimes it's just not. And you've got to make that determination. Hey, look, I'm not getting into this with you. Or maybe it's objectionable. You know what? I'm not going to go down this road with you. If they try, don't answer. Give me an opportunity to object. And only if the judge says you're to answer, do you answer.
So, like, I guess with the fireman, is it good to kind of have him say that about the beer, or should and not?
Yeah, I mean that's not because that's something you're just gonna, you know,
just kind of
glance or make it. You want to make it seem as insignificant as possible.
Okay.
You know, that's how you want to make it sound. But right, let's say for example, he had been written up on the job for falsifying I don't even know if there is a fire report, right? Right? Clearly that would go to credibility. It was like, hey, look, I'm not going through that. You know, that was 20 years ago. The other side hasn't brought it up with the court to seek the court's permission. If they try to go down that road, I'm going to object. Let's see what the court says. And don't you volunteer. Hey, well, isn't it true you did this? Yeah. You didn't even let me object. Right? And, you know, once the jury's heard it, you can't unring those bells. So make sure that you're, you know, part of prepping your witness is prepping them for those types of situations. If you have a piece of evidence you need to get in with them, photograph, a document, right? An actual physical item. Tell them, look, I'm going to try to introduce the phone through you. Here's the foundation we need to lay. You don't tell them what to say. You tell them what the foundation you need to lay. I'm going to show this to you. The jury needs to know that you recognize it, that you're familiar with it. You're going to identify it, what it is. Then we're going to move it in. Okay? Don't say, I need you to say you know what this is. Just tell them what you need. They'll connect the dots, right? So then they can truthfully say, did your lawyer tell you what to say? No, he didn't. And like I said, I think I told you guys in the evidence class, it's a cheesy thing, but everybody does it, and nobody seems to catch on. I always tell my witnesses, most important thing is just tell the truth, right? And so they always are asked, and why they ask this question, I don't know, but they always ask, did you meet with Mr. Nolan? Yeah. What did he tell you? Right? And instead of objecting, hearsay, or I let it go, because then they always say, oh, he told me to tell the truth. Right? And that's always the answer you get to that question. So why anybody ever still asks it is beyond me, but they do. So give your witnesses the tools that they're going to need to complete the task that you want from them. Okay? If you know you're going to be going into an emotional area with them, tell them, but don't tell them what you're going to ask, right? Because you want those emotions to be bare and raw there for the jury. Right? I never understood, you know, attorneys will come in and they'll prep their witnesses like, okay, here's what I'm going to ask you. Or they'll give the questions. Here's what I'm going to ask you. And then all the crying happens in the office and at home when they're looking at the questions. And then they come to court and there's no emotion because they completely prep themselves to that line of questioning. Just tell them, we're gonna go through some emotional stuff, and I just need you to, answer my questions. We'll get through it, we'll give you as much time as you need, but make sure they understand that you don't want to blindside them with anything, but at the same time, you don't want to prep the emotions right out of them. So a key part of prepping them is making sure that they know exactly what you expect from them. And for some reason, lawyers just get on this kick that they think there's something wrong with prepping a witness. Right? It's, in my opinion, it's malpractice not to prep your witnesses, but lawyers we always seem to play this gotcha game with each other. Like, oh, you meet with this lawyer before your testimony? Yeah. And the insinuation is that there's something wrong with that. There's something bad about meeting with the lawyer, as opposed to, just doing your job, right? And most jurors understand that, right? If they had a case and they were going to testify, they'd want to meet with their lawyer before they did it. So, there's nothing wrong with that, and you tell them there's nothing wrong with that, so that they don't give an answer that is like, well, yes, but, and it looks like they're making excuses for meeting with their own lawyers.
Wasn't it bad to bring it up yourself and say did we meet? What did we obviously it sounds coached at that point, but I mean.
Yeah, I've never brought it up, and I wouldn't recommend bringing it up. But telling them that might be something that's expected prepares them, because if you don't advise them, and then the defense attorney will ask a loaded question that makes it seem like there's something wrong, that you met and you guys, conspired and you fabricated all of this, their reaction might be one of shock and, oh, you caught me, because they don't know what to say, because they haven't thought about it. Yeah, there's nothing wrong with this. So prepping them for that is important. It's just a big thing is whatever you got going on with the case, make sure your witnesses know so that they don't undermine it. Right? If my theory of the case is that this crime was motivated by race, I better tell my witnesses that. And they may not even be a motive witness, right? Because if they're asked, well, why do you think they did this? I don't know, probably because they needed money. No, it's not because they needed money, it's because, right? It's because of the victim's rate, right? So it's, right, if you have those types of themes or theories, let your witnesses in on it. And what I like to do is, you don't want your witnesses talking about their testimony, and I always advise them not to talk about their testimony, but I would bring all my witnesses in together, sit around a table, and we'd have this conversation together. And I would just lay it all out so they're all hearing the same thing at the same time. Okay. And to the extent I needed to advise somebody individually, I would, but I always had a group meeting. And they all got the same lecture. So they all were exactly aware of what we were talking about. Cross-examination is a big thing in prepping your witnesses as well. You gotta tell them. And witnesses never seem to get it, or the lawyers don't do a good job of telling them. Like, I can't have you smiling and answering all my questions, and then as soon as the opposing counsel starts questioning you, you cross your arms and you start scowling, and you give them attitude. Right? Because as soon as you do that, you're undercutting everything you just did on direct. Answer their questions the same as you would on direct, and you're going to be fine. They just don't do it. And I know even witnesses, when I've advised them to do that, they still don't do it. Human nature kind of kicks in, and you get defensive, and you think things are being characterized, and you want to respond, and I get it, but to the extent you can tell them to do that, do it. Right, selecting your witnesses, orders of witnesses. You've heard me say this before. I'll say it again. You don't got to call every witness in a case. Right? If the witnesses aren't helping you, if they're not moving your case forward, don't do it. And with regard to the order, put it in an order that presents the case in an interesting, compelling, persuasive way for the jury. That's what you want to see. The DAs are so predictable, and I used to get so frustrated because the first person on the scene is usually the first witness, right? Or the victim's the first witness. Why? It doesn't have to be, right? That stuff, that could be filler at some point, unless that's the most exciting stuff. But, it's, you can be creative. I was explaining to the evidence class, somehow we got onto the topic of gang testimony and gang experts. And gang experts have really three things that they need to establish in a gang crime. They need to establish that a gang exists, doesn't matter what it is, right? Southside Indio. They've got to come and present evidence and give their opinion that this gang, Southside Indio, exists. Then they've got to give testimony that the defendant is somehow related to that gang. He's a member, he's an associate, he's whatever. But somehow he's tied to that gang. And lastly, they give an opinion based on a hypothetical that given these facts, this crime was committed for the benefit of, at the direction of, or in association with the gang. I always called my gang expert first. Said, tell me about the gang. He was my first witness. Tell me about this gang. And I showed graffiti, and I showed pictures of all the homies throwing up their signs and whatnot. Right? You've got to have what are called predicate offenses. You pick the worst ones. Tell me about this case about, People v. Garcia and Rodriguez. Well, that's the case where they all, they got this guy, they tied him up, they took him out in the desert, and they executed him, right? This isn't a murder case, but it doesn't matter. That's a predicate offense for the gang to establish that the gang exists. Then you got to talk about, is this person a member of the gang? Let's talk about the defendant, right? Let me show you his tattoos. Let me show you all his crimes that he's committed in association with these guys. Okay, let me show you all the pictures that he's in with the homies throwing up his gang signs and with guns and whatnot. Okay, and the jury is on the edge of their seat. They love this type of evidence. They're super excited and they're enjoying it. They hate the defendant. And this is probably a full day's worth of testimony. And I haven't even talked about the crime yet. I did in my opening statement. But I've already thrown so much mud and dirt on this guy, they hate him. Now I'll get into my crime. And then at the end, I'll call my expert back. So, assuming all of these facts, would you say, in your opinion, this was a gang crime or not? And they give that. Nobody does that. I always did. And to me, it just made such sense. Like, why wouldn't you do it that way? I'm sure people had their reasons why they didn't, but everybody goes through their crime, and then they call a gang expert at the end, and they go through all of that. And I think they lose an advantage of getting the jury on your side early and an effective and legal way, right? It's kind of like you're talking about character evidence, for that reason that they can't use it for, but you're talking about it for the reason they can use it for, because they're going to make the connection and use it for that other reason. I already know they hate the guy before I even start talking. He's already guilty at that point. So don't be afraid to be creative with how you want to present your evidence. It's your case, it's your presentation. Sometimes chronological works, sometimes it doesn't. So if it doesn't, don't use it. Okay? So, principles of effective direct examination, right? These are some of the main things you want to think about as you're putting your direct together, right? You want to ask clear, understandable questions. Lawyers, for some reason, like to hear ourselves talk, and we think it makes us look smarter when we use these big words, or we ask these long, drawn-out questions, and for the most part, it's probably confusing the jury, and it's not getting you anywhere. So, to the extent that you can, ask just clear, easy, plain English, do it. Okay? It talks about this theory behind blocking and headlining. Not a bad idea. I mean, if you have a witness that you're going to be talking about multiple different things, I need to talk to you about the relationship between you and this other person. And then I'm also going to need to talk to you about the events that happened. And maybe I'm going to have to talk about it, maybe damages or something, right? What happened after the events that took place. So to the extent you can block your questions in those sub areas and headline them for the jury, just with a little preface, right? Okay, I'd like to talk to you a little bit about your relationship with the defendant. Do you know him? Yeah. How long have you known him? In what capacity did you know him? Right? Things of that type of nature is a good thing, and that's not the same thing as leading to tell them what you're going to do. Okay, and when you finish one area and you're transitioning to the next, right? Okay, you just okay, thank you. Now that we have a good understanding of your relationship, I'd like to direct your attention to this date. Let's talk about that. And then you just kind of transition into the questions there. There's nothing wrong with it. Every once in a while, somebody will ask a stupid objection or make a stupid objection. There's no question, Your Honor. And usually the judge will say, move along, and the jury appreciates it. Okay, the other counsel's just being a jerk because there was nothing inappropriate about that. So don't be afraid to do that. Just to kind of set the scenario for the witness. And that's stuff that you would have done before then. Right? Personalize the witnesses. It's an important part. I always it depends on the type of witness it is, right? But if it's my main witness, like if it's my firefighter, you want to personalize them. But I don't think you got to do a whole lot of effort to personalize them. If they're going to be on the witness stand for any length of time, the jury's going to get a feel for them just in watching that interaction. Okay? So I don't know if you get too much bang for your buck saying, and where'd you go to elementary school? And, were you popular then? And, did you have a lot of friends? Oh, you played football. Oh, you're captain of the football team. To me, that's kind of transparent, to the jury, and they see it. I never went that far, but laying a little bit of groundwork as to who they are, what they do for a living, and where they live, is totally appropriate. It helps get them comfortable on the witness stand and lets the jury know a little bit about who they are. Okay, which is good, because even though the witness may be a good witness, not shy about talking in front of others, when they first take the witness stand, they're going to be nervous. They just are. And it doesn't matter how often they try to tell you that, they're going to. Evident principle number 4, right? Incorporate your pathos. Remember, Judge Dean Tolan, has talked about that a lot, about how you've got these 3 components to convincing a jury, right? And one of them, of course, is getting this emotional component out of the question, using specific language, using your tone of voice, and modulating that can go a long way, right? Proximity with the witness and so on can impact that as well. Let's say you're asking a very emotional set of questions and you're just not getting the reaction that you want. Sometimes maybe you help them out with that. Or, are you okay? Do you need a break? And they're like, oh yeah.
Yeah, sad.
Right? This is the emotional part. Oh no, I'm okay. All right. Look, and the reality is, they're sitting across from the jury room, at least here in Indigo. All the other courtrooms across the land, they don't do that. The witness is right by the jury. But here in Indigo, the witnesses are completely across the courtroom from the jury. So the jury is hard pressed to pick up on little things with the witnesses. They just can't, because they're too far away. Now, you can tell somebody's smiling or crying, if they really are, but the little things they're not going to pick up on. One of the bad things about the way our courts are set up, but they are. Right? And another thing is, right, when you're trying to get that emotional draw, walk up to them, walk closer to them. Lower your voice when you're questioning them. Don't lower it in such a way that the jury can't hear, but lower it so that they know, okay, right? So there's something about you lower your voice, they start listening, more, because they want to hear. Talk slower, right? Those are all things that you want to do when you come to that emotional stage, because part of the emotion that the jury is going to pick up on is what you help deliver as the advocate, right? If you're not emotional at all, or you're insensitive to the subject matter that you're talking about, and you just kind of matter of fact, or just in a stern voice and just no modulation at all, and so tell us how you felt that night. And they start crying, and so you were sad. Right? And this subject matter makes you emotional, right? They're not picking, right? You're kind of hurting your own emotions there, right? So there's this interplay that takes place between the attorney and the witness, that you can help draw out emotion that maybe the witness isn't giving them.
I expect you to cry when I direct examine you.
Special
You better start crying.
And if he does it, just offer him, offer him some tissue. Would you like a tissue?
Just sample a little bit.
Acting tricks, just plug your hairs in your pocket.
Yeah, exactly.
Right? Make sure you, right, you've got to tell the whole story, but don't tell it in such a way that you're leaving out the important parts, right? And any timeline is going to start over here, and it's going to build up, something's going to happen, and then it's going to dissipate somewhat. When you get to that important part, spend some time with it, right? Don't just run right through it and, oh crap, I'm done. And I didn't really get a good description of that at all. Right? If your witness isn't giving you the descriptions that you want, help them. So I was at a bar, and I was drinking, and this guy started talking trash to me, and then he pushed me. And then he hit me, right? And then he, then he ran away. Called the police, I got his license plate, gave a description, and we're done. Okay, I got a kind of general gist of what happened. But wait a second here. Okay, you're there, you're drinking, how much were you drinking? Had you noticed this guy before? Was he with anybody? Were you with anybody? Develop the actual story. Okay, he's talking trash. What did he say to you? Right? What prompted this? And use the language that they use, right? Develop that important part of the case, and he hit you. What were you doing when he hit you? Well, I had my back turned to him. I was at the bar. Oh, okay. You didn't see this coming? Well, actually, I kind of caught a reflection, and I saw somebody coming up, and then bam, it just hit me. Okay? So, don't think, well, I've got my story out. I rented a jackhammer. I went home. I was using it. It hit a rock and jumped up and cut my toes off. Right? And now I can't be a fireman. Okay? There's more to that story, right? There's more.
Get it out.
There's more to that story. So when you get to the important parts, spend some time with it, right? If there's gaps, fill in those gaps. Whatever those gaps may be. What were you wearing? Okay, why were you wearing that? Why weren't you wearing this? Right? Better have an answer for it, because he's gonna, question about it. Why
I
weren't you
wasn't actually.
Why aren't you wearing the steel-toe shoes, right? Well, I've been a fireman my whole life, and I wear steel-toe shoes, and you know what? They're not effective. They just don't help. Whatever. I know that's not the fact, but
Says the man who still has his toes after all these fires.
That's a really good process.
Yeah.
You still did? How about this time?
Don't be afraid to use, demonstrative evidence with your witnesses, whether they're timelines or their documents or their charts or whatnot, storyboards. Just, be careful. I've probably seen it 30, 40 times. And you see it happening and you're sitting there like, what the hell are you doing? Right? There's a whiteboard behind the witness box. And they're like, hey, could you, why don't you show us right here? And they turn around and they start drawing on that. That whiteboard can't be evidence, right? You can't mark it. It can't go back with the jury, right? If you know you're going to want to have your witness draw something, make sure you have paper there for them. Make sure you have markers there for them. Make sure you have different colors if you want it to be color coded. Make sure you tell them, hey, I'm going to ask you to draw a little diagram here. So in their minds, they already are aware of that. Maybe they've already sketched out a diagram beforehand because they want to practice. So if you're going to have them do that, make sure you tell them that and then have them do it and mark it and make it an exhibit. much more powerful than to have something pre-prepared, to have them do that in front of the jury. Okay, especially if, I don't know, right? Somebody's lost a leg, right? Or something like that. Could you step down here and over here to the board? I'd like you to draw. Let's take a look at what happened here. And one of the things you really want to do is to let them get a look at it, right? To get a look at what's going on here, right? Maybe it is a fight, and your guy's small and the other guy's big. Why don't you come down here? And the jury's seeing you're not a big person at all. So, give them the opportunity to tell their story in a way other than just their words if you think that's going to be effective. If there can be a diagram, use it. If you want them to make a timeline, sometimes you'll make a timeline and you'll start off, right? Okay, so this happened first, right? And then this happened. And then this happened. And then another witness comes up. And you add to the timeline as you're going through different witnesses. So to the extent you think something like that might be helpful, don't be afraid to use it with your witnesses. Double direct can be an important thing on an important issue. Some lawyers do it every single question. You ask the question, they give you the answer. So, where were you that time? I was at the bar. Oh, so you were at the bar. And what happened when you were at the bar? Oh, well, I was at the bar and I met some friends and we had some drinks. Oh, so you're at the bar with your friends having some drinks and then what happened? Oh, some girls came over and we were talking to them. Oh, you're at the bar having drinks with some girls, and then what happened, right? And you're basically just repeating what they're saying. Very good tool in moderation, right? If you do that with every question, you're just irritating the jury. Like, okay, we heard them. Why are you repeating everything that you said? But to the extent you have an important point that you want to make, you want to say this is a race crime. Well, this guy walked up to me and he said, "Hey, you MF and spit, whatever. I'm gonna kick your butt." Well, wait a second. This guy walked up to you and said, "You're an MF and spit." Yes. Right, so you've repeated it, but now you've done it for, is it objectionable? Yes, right? It could be, you asked and answered, whatever. But you're repeating it for emphasis because it's a point that you want emphasized with the jury. Okay? So, to the extent you can do that, if there's an important thing that you really want the jury to get and you really want to understand, right? You got your DNA person on the stand and they're like, so in my opinion, they never say it, right? This person could not be excluded from this many billions and trillions. And I say, so does that mean it's a match or it's not a match? They hate saying it, but they will. If you just tell, I need you to say it's in, right? And eventually they will. And then when they do, it's like, so I understand, after all this stuff you did, this is him. Yes. Okay, all right, and you've repeated what they've already said, but you've repeated an important point that you want to make sure the jury understands. Right, and if they just say, oh yeah, and this is him, okay, well, thank you, nothing further. Counsel is your next witness. Okay, did the jury catch that? Did they really get it? What did you do to make sure they really caught it and to emphasize it? you have to control that by your timing, by repeating it if it's an important issue, by not just rushing on to the next thing. Because if you do, then they might have missed it. And so you have a role as a witness of making sure that whether it's through repetition or it's through your timing, or if it's through your focus on going back, like maybe you have them and maybe you plan it this way. I'm going to ask you this, what happened. And what I'm going to want you to do is give me a general version of what happened. Okay? And then I'm going to go back in and I'm going to fill in some of these holes. Okay? And then I'm going to come back a third time and I'm going to solidify all of these different aspects of it. So you've now basically been able to tell your story 3 times to the jury, but it's new and different because you're filling in gaps. You're not just having them retell it. Okay? And so by doing that, it gives you an opportunity to stress your side of what happens, as opposed to, they just hear it once. Getting to hear it, Judge Sterling said, power 3, right? They hear it 3 times, it's in their mind, right? I don't know if it's 3 or if it's 2 or 4, but you have to be the judge. You have to be satisfied. Have I emphasized this enough? And am I getting the impression from the jury they get it? They get this important part of my case. Exhibits, demonstrative aids. That's kind of a given. Oh, I hope you guys appreciate that. Calling a witness, asking them a bunch of questions, moving along. Call the next witness, asking a bunch of questions, moving along. Doesn't make for a fun experience for the jury. Right? They want to see the pictures. They want to watch the videos. They want to see the gun and the knife and the, and the stumpy leg or whatever it is. They want to see it. Right? It makes their experience more interesting. So, right, to the extent that you can utilize exhibits and demonstrative aids with your jury, with your witnesses, do it.
I don't think we can show total rank stipulated to not show.
Yeah, we stipulated not to show the shows.
Disclose material witnesses, just material weaknesses. Okay, that's the key part, right? It's got to be material, right? If it's not an important part of the case, don't disclose it. If it's a weak point, then the other side's going to look silly trying to make a point out of it and score points off it. The jury will see it as weak too. If it's important, if it's material, you address it. Don't let them address it, because you address it and you couch it in your terms, not on the other side's terms. So the key is understanding whether it's important or not. Okay, and you've got to be the arbiter of that. And you've got to be willing to live with it, right? If it's not an important thing and you bring it up, you kind of look silly. Why are you telling us that? It's like, you're going to tell me you had a jaywalking ticket, 20 years ago? Why are you telling us that? Right? You're hurting, you're undermining your own witnesses' credibility. Well, if the other side brings it up, really? Jaywalking? Who cares? We don't care. You look like you're just trying to, pull a fast one. So you make that determination. If you think it's an important point, bring it out. If you don't think it's an important point, or you think you can effectively argue it away, then don't. And you've got to decide that for your own case. Um, so, I wouldn't ask them challenge questions, but I mean, that's one of those things. If you're going to ask them to do anything, make sure that you advise them of that beforehand. Don't surprise them on the spot. Hey, can you come down here and draw this? And they're looking. And principle number 10, adopt a winning attitude. You know, that was a little bit about what Judge Sherman was saying. Like you've got to bring the energy, right? You've got to make them believe that you're confident in your case, that you believe in your case, that you know what you're doing. It says don't rely on notes. I mean, that's to a point. Like I always had in my trial binders, I had sections on each witness, and for me, my witness sections were just bullet points. And I didn't put down what I expected the answers to be, because you should already know your facts. And I don't care what the answer they give. I know what I want them to say, what I need them to say, and I'm going to stay on them until they give it to me. And then I've got all of their statements, whether it's a police report or a recording or a transcript or a deposition, or I've got that all there handy in case I need to go to and say, oh, you know, what is it? You're saying A, but didn't you say B before? No, I don't think so. Could you look at this and see? Sometimes you need to refresh the recollection of your own witnesses, and to the extent you need to do it. I wouldn't say don't have no notes. I would say don't write out your questions, or to the extent you do write out questions, make sure that you have a corresponding outline that you can follow. Because ideally you want it to be a conversation. And you want to be asking questions and getting answers, and asking questions and getting answers, and together you're telling this story that the jury's like, I want to hear this. If you're just asking questions and you're not listening to the answer, and you ask a question to something they've already answered, everybody knows that, but you. And if you knew the answer to it, you wouldn't have asked that question, and everybody else has heard. And every once in a while, a juror will say something. Then they'll say, oh, he said it was blue. Oh, you don't want that. You don't want the juror answering your questions for you because they heard what the witness said. So to the extent you can develop a conversational tone, it ensures that you're listening, you're hearing what they have to say. Maybe they say something you didn't anticipate as better than what you thought. And if you're not listening, you might have missed something that helped your case. So try to do that. Don't be afraid to move around the courtroom to some extent. Of course, it says don't echo the answers. That's where whatever they say, that's the preface to your next question. Don't do that. This tells you to stand next to the jury box. Sure, at some point. Sometimes I like to stand next to the jury box so that my witness, if they're looking at me, they're kind of always looking at the jury. And they're not looking at their opponent, whether it's a defendant or whoever they're suing in civil court. It takes the
Hard to do here.
yeah. So I mean, it's a good tactic to do that. Sometimes you got to walk up there and get next to them, right? And so you do that, right? You walk up to the witness box and you do it. Right? Redirect. I hate the way lawyers do redirect. There's this sense that
I've got to respond to what they brought out. You should only be responding if there's something new that you need to address, or you didn't get out everything that you wanted to, like, oh crap, I wasn't paying attention. I forgot this whole block of area I wanted to question you on. Or sometimes your witness will try to say something and the opposing counsel will shut them down. Say that's a yes or no. They're like, no, I need to explain that. Come back to that on a redirect. If for no other reason you make the opposing side, you remind the jury that they were a jerk. I know you were talking about this document. You wanted to explain something, and counsel wouldn't let you. What was it you wanted to say about this? Right? It's just a little dig. It just reminds them, hey, they didn't want to hear your answer. Even though it was totally appropriate, that they didn't want you to, they only wanted the yes or no. So on redirect, be careful. If the other side didn't bring up anything new, you don't have to respond. But they do. And then there's a redirect. And then there's a recross. And then there's a re-redirect. And then a re-recross. You'll see them go back and forth. I did this once. I still remember. I look back on it and I think, God, we must have looked like idiots. The whole argument in this case was I had victims who were shot. Fortunately, none of them died. The argument was self-defense. And the guys said I was shooting over everybody's head. And one of my witnesses are on the stand, and it's like, he was pointing directly at me and shooting. Could you demonstrate this for the jury? Put his arm out and was shooting. Your Honor, could the record reflect his arm is parallel to the floor, 90-degree angle with his body straight forward. Record will so reflect. On cross, well, wasn't his arm actually slightly higher such that the shots were going over your head? But it was a leading question. Isn't it true? And no. Your Honor, could the record reflect that she described how the arm was, and she got him to admit that he was being shot at, and the exact angle of the arm, he doesn't know. So you don't know. It could have been like this. It could have been. And I stood up because I'm going to make my point, but he was pointing at you. Yes. And then she stood up, but it could have been up here. Yes. But you remember seeing the gun pointed at you. Yes. And we went back and forth like 4 or 5 times. And actually the judge intervened and it's like, I think the jury gets it. Like, what was I thinking? But,
Yeah, and they could just go back and forth like every single witness.
Yeah, and I'm sure it was a no-brainer for the jury. They got it. Either he clearly wasn't pointing down because I had 3 victims that were shot. And lo and behold, in this party of 50+ people, he had a beef with these 4 guys, and 3 of those 4 guys got shot. That's who he had a problem with, but he was shooting over their heads, not at anybody. But the three guys that got shot all happened to be the 3 guys he had a problem with. And fortunately, they convicted, but I look back and I was like, my supervisor was in the room too. I was proving how much I could fight for my side and look like an idiot. So be careful, okay? If there's nothing to go over, and let's just say, right? You go through this, you're direct. You get everything you want out of your witnesses, right? And let's use a firefighter for the example. You decide, you know, I don't think him drinking a beer is a big deal. I don't think it is, so I'm not gonna question him about it. Cross-examination comes, and he's hitting him on a whole bunch of stuff. Just hitting him, but you notice, and then he's done. You didn't ask him about the beer, right? Do you get up and address that with on redirect and give him an opportunity to come back on recross? Because he may be sitting down and he'll look,
Then I just call him as my witness, and my case is changed.
eventually, right? But you know,
Yeah.
and why bring it out? Why give them the opportunity? If you want to shut it down and you don't want to give them another shot, let's say they were just having their way with your witness, right? They were just bam, 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 bam. That's not going good for me. You're done. Don't redirect. Don't give them another shot. When they're done, let it be. Let's move on to something different. And of course, right, you got certain special witnesses. You guys all remember how to jog people's memories, right? You can ask them leading questions for purposes of jogging their memories. You can show them things to try and refresh their memory. And then, of course, we're not going to get into it with past recollections recorded, but you know, you can. But that has to be something that they actually put down in writing or adopted. And so just know that that's a tool for you, right? You got those three things to get into if you got somebody that just doesn't remember. Right? You lead them first, you show them something to refresh their memory. If that still doesn't work, you can go to past recollection recorded if you have something that you can use for that. Otherwise, they just keep saying they don't remember. Nothing you can do. Okay, there's a whole another process that's kind of beyond our efforts here. If you don't think their lack of memory is sincere, if you think it's being feigned, then you can do what's called greening the witness to demonstrate that if the court agrees, then all of their prior statement just comes in. But you don't have to worry about greening anybody for our purposes. Adverse witness, right? Let's say you do, you know, maybe in a criminal case, you couldn't call the defendant in your case in chief. You could call the wife in your case in chief. Right now that granted, there's some special privileges and whatnot, but I don't recall any of that being asserted in the case. So arguably you could call the spouse as a witness, and she's probably not going to be friendly to you. So you ask a few questions and you demonstrate the hostility, and then you ask the court to declare them hostile, and you get to lead them. And then what does that do for the opposing counsel? Once they're declared hostile, they don't get to lead the hostile witness. You do. Then they have to direct your witness with open-ended questions, and you got to take it out of their hands at that point.
So when you redirect a hostile witness, you can't ask leading questions. It has to be open-ended.
No, you can't.
Oh, you can still.
No, what I'm saying, but once somebody's declared hostile, they're declared hostile to your party.
Mm-hmm.
Okay, so then the other side has to direct that. When you're done and they have their cross-examination, they don't get to lead their witness because that witness isn't adverse to their position. They have to ask open-ended questions of your witness. Mm-hmm. So, you know, it's rare.
Yeah.
It's rare.
Yeah.
I've had,
You have to a biased person.
right, maybe a handful of times. And, you know I had one that was fantastic. It was a defendant's sister. And she had a lawyer sitting up there with her, you know, whispering in her ear with every question. And of course, that's the optics I wanted. She got so frustrated she wouldn't answer my questions, and she's like, "I'm fucking out of here." She got up and walked out of the courtroom, and we all sat there. The judge said, "Deputy." Deputy went out and got her and brought her back. I was like, okay, I think that went well for me. Because that's going to be rare, but every once in a while you have these examples that actually worked. So, child witnesses, I would just say use your common sense, right? Talk to them like a kid, talk to them easy, and don't beat them up, even if they're not your witness, but then engage them, right? If they're coming across to you like they're a little punk, and that's how they're coming across to the jury, don't treat them like that. The jury will appreciate it. They see what you see. And so, if you got a legit little kid who's just scared and doesn't want to be there, then you treat them with kid gloves. But if you got, an 11, 12-year-old who just thinks he's, this hot stuff because he hangs out with the gang or whatnot, he's a little punk, and okay, then no need. Right? You're going to have to gauge that. we're not gonna mess around with exhibits. You guys, do you have an understanding about exhibits? Yeah. Right? If you want to do it, go to your foundation. You know what your foundations are, or whether it's for whatever it is that you want in. Know which witness can lay that foundation for you, and you just ask them those questions, right? Do you recognize this? What is it? How do you recognize it? Whatever foundation's needed, and then you publish it from there, right? You don't publish it until the foundation's been laid and you get the court's permission, and then you publish it. But the key is, and I still do it with every case. If I got anything that's out of the ordinary that I know I'm going to try to do, I got the little foundation there in my notes, just so I can see it. And I like to use the words of the statute. If there's a statute that says, "Here's how you get in a business record," I use the words of that, so the court hears I'm using the words of the law, and they recognize it, and they say, okay, he's laid the proper foundation. Because they don't know the rule, but they know it enough that, hey, that sounds familiar. That sounds like he's hit everything. So I try to do that.
We're doing federal objections, right?
Yes. Yes. Okay. Cross-examination. Right. Here's what we need you guys ready for. Okay. Do some thoughts. Right. Have some points in mind as to how you're going to cross-examine somebody. Make a decision first whether you need to or not. For purposes of our class, you need to. Right, we're going to want to see you cross-examine. We're going to want you to be using leading questions, right? And the whole point of leading questions is you are putting the story that you want out there. It doesn't matter. Right, your leading questions aren't, I want to ask a bunch of questions that I can get a yes to. You don't care what the answer is, if it's yes or no. The goal is you're putting your version of events out there by way of your questioning. And if they say yes or they say no, right, clearly if they give you something that you can clearly demonstrate is false, you prove it to them, you impeach them, and then you move on to the next thing. But in all reality, a good cross they remember what you said by way of your questions, not necessarily what the witness's answers were. Okay? So they tell you to wear the white hat is principle number one, right? It's not necessarily the time to get mean and nasty. I would agree with that. But it's also not the time to sit back and not press your case, right? You've got a version of events that this person can help you with. And what I mean by help is maybe they were a witness to this whole event. This happened, this happened, this happened, this happened, right? No. Okay. Right? You through your questioning, you're laying out which you believe the facts are. Okay? Only use leading questions. Ask one fact, one question. Right? That's what you've heard them say. Take bite-sized questions or small baby steps. That's what you want to do. Ask one fact. Get a yes or no. And to the extent you can build, yes, 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 and then ultimately they're going to say no at the end, it looks silly. Right? So this is true, this is true, this is true, this is true, this is true. But when you put all those together, this is what the response should be, but you're going to say no. So you can build that sort of inference chain where the jury gets it, right? Because they're going to be following along and they're going to say, well, yeah, if that's true, that's true, that's true, that's true. Yeah, all of that's consistent with what he said, and now you're just giving what should be an obvious answer, you're giving the opposite. Okay, but it doesn't matter that they give the opposite because you've already made your point by locking them in to yeses on all of the easy stuff. Okay? Right? You went to the store, didn't you? Right? And you went there to get a jackhammer, right? You're a fireman, right? So you wanted the biggest, strongest one that you could get. Yeah, and you've operated these types of machineries before, right? Yeah, and you know how to handle yourself around machineries. And, you signed this document right here. It says you understood the risks and whatnot. And you were checking out that girl right over there. You weren't really paying attention. Well, yeah, it was. Right? It doesn't matter at that point because I'm leading you down the path that I want to go. And then ultimately, so it was your choices that led to this accident, not any fault of the defendant. No.
That may be like the last question you don't want to ask, though.
Right, but you see, you've led them. True, and sometimes you don't want to ask that last question, but you want to lead them down to this path
Where it's obvious. Here's the question.
It's obvious.
And then you sit down.
Yeah, and it's obvious what just happened, and then and then either you ask the question, it doesn't matter what the answer is, or you don't ask it because they're gonna make that connection for them. Okay, maintain control by repeating the questions, right? And there's a ton of ways to do that, right? And you heard some from our speakers, right? That's thank you for that. That's not the question I asked, right? Or that's a great answer to a question I didn't ask, or okay, however you want to phrase it, don't just turn away, right? Get the answer to the question you asked by repeating it. And it only helps you if they don't answer because they come across as evasive, and evasiveness leads to concerns about whether they're being credible, whether they have to hide, why aren't they answering your questions. I always like to say, for me, the phrase I always use is, look, I understand you have a story that you want to tell. Okay? But right now, I just need you to answer my questions. Right? And I just to plant that seed with the jury that he came here to tell a story, not necessarily to tell the truth. Right? He's got a story in his mind, and that's just the language I use to kind of get that point across. And you just keep asking it until you get enough. So, right, I never like to ask for admonitions. Right? I want them to think I'm in charge of the courtroom, not the judge. And ask it, oh, Your Honor, could you admonish the witness? Just looks,
It's whiny.
it's whiny. It's like, okay, maybe I don't have control of the courtroom. I don't want the jury to think that. Because usually, for the most part, the judges sit up there, they're either on their phone, they're looking at their computer screens, they may or may not be paying attention. I literally had a judge fall asleep in a jury trial. So I'm not conceding that this isn't my courtroom when I'm there. I'm acting as if it is. Of course, with deference and respect to the judge, but I'm going to handle the witness without courtroom intervention if I can. Interrupting them, I don't. Like I said, I don't think it hurts you if they just wander off, because then as soon as they don't answer the question, right, make sure you move it to strike, and that's stuff that the jury can't even consider. And what they're going to remember mostly is, I didn't answer any of your questions. Right? He just came up here and just said what he wanted to say, and that's how you can take that and just,
How do you deal with the sleeping judge? Do you just call for the answer?
Well, that's actually what we did. It was, we're going, and one of the juries, and I was questioning a domestic violence victim. And so I walked over to the deputy and just went to sleep. And, the deputy started coughing, the clerk was looking. I came over and just started, and eventually she kind of like opened up, and I questioned. Nobody said a word. Nobody said, Your Honor, are you okay? I just kept questioning. I don't want to embarrass her in front of the jury. And, and of course you can object, but the main thing about that is not necessarily objecting to object, but you've got to make sure if you've asked a question and they've rambled on, you've got to make sure, that was non-responsive, can we move to strike it? Sometimes I wouldn't even say objection, and you've got to make sure that you strike it, and the judge will say yes. And then go back to them. Okay. I know you wanted to get that off your chest, but here's the question again. And you ask them the exact same question until they give it to you. And if they never do, their credibility is shot at that point anyway. So maintain control by listening to the answers, right? You gotta listen. You've got to hear what they have to say. Right? If they're trying to be evasive or they're trying to add additional information, you've got to catch that. You've got to make sure that you don't let it stand on the record. Otherwise, if it's in, your opposing counsel can argue that in argument if you haven't gotten it stricken. It is in evidence. All right, principle number 6 is don't ask questions that lose control. Don't ask open-ended questions. Questions that include characterizations, questions that refer to the witness's past testimony, or they invite an explanation, or the one question too many, right? And there's tons of examples in there, but you want to keep control through your choice of questions. And look, it's a give or take. Okay, these are general principles. Sometimes you're cross-examining a witness and you need to ask them an open-ended question. You need to. So, don't be afraid to do it. If you need them to explain something, then make sure you do it. But just be smart about it, right? Don't let them ramble on. If you're asking them an open-ended question, make sure it's with sufficient specificity that they can answer that small portion, and then anything beyond that you can get rid of. Number 7, make sure you're protected on every question. That's you don't want to ask a question that is somehow opening you up to other things. Well, you asked a question, Mr. Nolan, so now everybody gets to hear what their answer is going to be. Right? Make sure that you're asking questions that control what the witness can or can't do. Okay? And you don't want to be opening any doors that the judge is going to let the witness just stroll right on through that you have no control for. And one of the best ways to make sure you're protected is to don't get too broad, right? The one fact, one question, piecemeal, bite-sized little approach is so effective because it does all of those things. All right, if you ask these grandiose, really involved questions, right, you're risking allowing them to really respond, even if it is a leading question. The judge might not agree that it's just a yes or no. Okay, arguing using cross-examining questions. That's clearly your leading questions are an attempt to paint the evidence how you want them to see it. Right? It's the shade towards the inferences you want the jury to draw. So, and you're arguing to the extent that you're getting this in front of the jury from your perspective and hoping that the jury is starting to draw the same conclusions that you've drawn or that you're ultimately going to ask them to draw. I don't think you stand up there and say, well, my client's really not guilty, is he? Because you didn't see him do this. That's not the type of statement you want to get them to make. So you're not arguing. You're just doing things that you're leading them down factually based on your scenario, not their scenario.
What do you think about continuation, the jury's memory, we're going to talk about continuation between witnesses? Like let's say that you're doing that, you're trying to get out your story, but you want it to almost mirror someone else's story, or maybe like flow in a way that wow, those lock into place if you think about once you get to the truth.
Mm-hmm.
How does that work? Is that effective or does that not work?
You got to be careful with it, right? And you can't use it too much. But to the extent you can say, right, we've heard testimony that said this occurred. But actually, this occurred, right? And you get this, to agree or disagree, right? You're to the extent you point them to prior testimony, you can do that. That's permissible.
Let's use an example. Let's say I want her to say that you came in screaming you're a terrible person when you arrived at his house, and then I want to bring up my client later on and say she was leaving these in your box saying you're a terrible person. You know what I mean?
Your job.
Yeah, but the two stories, I can't get her to authenticate that.
No,
that letter.
but you can use consistent language throughout.
Right.
right? If you want it to be, right, she's out of control, she's screaming, she's, a stalker, then you use that same language, the same words, the same phrases with each witness.
Okay. And you think it works in the jury's memory? Or?
Absolutely.
Okay.
Absolutely. That's why for me, I was 100% of my trials, in front of a jury had been criminal trials. So I always had the elements. I always used the law. That was the language I tried to get the jury to hear over and over and over and over again. So when the judge talks about it at the end, they know exactly what we're talking about, because that's what I have to prove. I have to prove A, B, and C, and that's it. So my language of A, B, and C mirrors the elements, and I use that throughout. To the extent you have loaded language that you want to use, right? Don't say, well, she yelled at you, right? And then the next one, well, she screamed, right? And then she got loud, right? No, use the same word or the same phrases with everybody, and that repetition will stick in the jurors' minds with what you're trying to paint for them.
Huh?
Okay? We got about 5 more minutes, guys, if you want to keep going, or you want to jump out and take a break. Impeachment, right? Impeachment is a must, right? To the extent you can. You want to hit them on their biases, you want to hit them on their prejudices, if they have an interest in the case, if they have a motive to lie, you want to present that from your perspective. Don't ask them, you've got a motive to lie, right? Or, hey, you're biased in this case. Tell them, right? This is your boyfriend here, right? And you would do whatever you could to make sure he doesn't get in trouble. Right? You load the language up to demonstrate that there's a bias. And it doesn't matter, right? They're expected to say no, but the jury will now hear like, yeah, mom would do just about anything to help their kid. Yeah, girlfriends do help their boyfriends. Yeah, oh, you're the president of the company? Yeah, you don't want to see your company found liable for whatever. So you want to make sure that you have the ability to bring that out on your terms. Right, you've got impeachment, you've got observations, right? If they failed to perceive something, or they were in a position where they couldn't perceive, make sure you point that out. Hey guys, you clearly didn't have the ability to see what you think you saw, or you didn't do it, right? So any lack of perception is an opportunity for you to hit them with. Faulty memory, same thing. And everything with regards to impeachment is a building process, right? It's multiple small questions that hit them with the big questions, so you really didn't see what you thought you saw, right? Would that be fair to say? And sometimes you get the witness to identify it. Yeah, I've kind of boxed myself in on here. Inconsistencies, of course. Hit them with that if you have them. Right, they said one thing before, said something else again. Make sure that you confront them on that. Criminal record, you do it. I've never felt like you got a whole lot of mileage out of that, but I mean, you got to do it if you got a witness that has a felony, right? Because you got to get the instruction that says, hey, if you find them a felony, you can not believe what they have to say. So you do it, but I just never found that all that of a compelling argument. I've never stood up in front of a jury and really beat my chest and said, don't believe this witness because, you're a convicted felon. Right? I better have a whole bunch of other stuff to offer them than just a felony conviction. Non-conviction misconduct, right? If you got that moral turpitude conduct, If it's big, you use it. If it's not, just be careful. You hit them with stuff that you think you are gonna move the needle with regards to credibility. If it's not, you see Penny even bringing it up. So, be careful with stuff like that. Don't use everything that you can. They talk about impeachment by omission. That's just you're hitting them. So, well, you didn't do this, and you would have thought that somebody in that position would have done that, right? And prior consent statements, we did refresh your recollection. Common sense is a big thing, right? If you got somebody that's done something that just doesn't make common sense, walk them down that line and show that, wow, this doesn't make any sense at all what you chose to do as opposed to what everybody else would have done in that situation, including probably your 12 jurors. So they probably want to acknowledge that it didn't make sense, but you walk them down that road, and you maybe you don't ask that last question. You just leave it with the jury to conclude like they were idiots. That didn't make no sense what they did. And sometimes witnesses just do dumb things and they can't explain it. And maybe you don't want them, because if they're extremely credible, if they're coming across credible, they might acknowledge it. Yeah, I know it doesn't make any sense. I can't tell you why I did it, but just know that I did. So, questions on cross-examination, that's where you're going to have probably the more difficult time is kind of finding that balance. What you don't want to do, you've heard Dean Dolan stress this probably 100 times. What you don't want to do is just repeat what the other side said, and just reinforce their version of the story. Make your points, small facts, one fact, one question. Go down that road, hit them if they've got a bias or an interest in the case. Hit them with inconsistencies, hit them if it just doesn't make sense. Got that fireman. It's all about safety. And sandals, drinking beer. Doesn't make sense.
Makes perfect sense. This is off time. It's not safety.
So, next week, you guys all got your assignments. You all know what you're doing.
Direct and crossing witnesses.
You know who you're directing and crossing, and you've got exhibits in your book. So next week, impress us, right? Come in and have your directs prepared. Make sure you get all the information you want. Have some thought put into your cross-examinations, and don't be afraid to introduce an exhibit here and there. And I don't care if it's a blank piece of paper or it's a piece of paper that says contract or whatever.
So we don't
Text
need
message.
we don't need like make copies of.
No. We don't expect you to do any of that. But to the extent you can demonstrate, hey, I'm going to walk up to this witness and you recognize this, is this a text messages you sent or what have you, then do it, right? And if you want to help each other out, don't, I'm not telling you to mess with each other. I'm saying help each other out, right? So if you want to want to not remember something as a witness, so that they can then refresh your recollection.
I have no idea what you're talking about.
But you're playing my defendant.
Okay. I have no idea what you're talking about.
Right? We want to see you guys using all the tools that you have at your disposal, and to the extent you can coordinate amongst yourselves and help each other out. Say, hey, right here, I'm going to forget this.
So this is an opportunity for you to refresh my recollection or whatnot. Just, show us what you can do. Show us that you remember those objections.
Someone write like $100 bill on a white piece of paper, hand it to somebody. So,
Is this what you said? Yeah. Yes, it is. Thank you for refreshing my recollection.
All right, guys, and just like that, all done. Piece of cake, right? Speaking of cake.
Well, as I say, I'll take cake if you have pieces of cake.
I would too. Unfortunately,
I hope so. Thanks for this.
absolutely.
And did Irene tell you guys that there's going to be one day when I'm leaving at half point and then one day where I'm going to be on the camera?
She didn't mention that.
Okay, it's
Right.
the second and third week of November.
Okay.
So I'll let you know before
But to
then.
the extent we know where you are, we're good.
Nice of you to show up.
Right.